Excuse me. Listen.
Constitutional right.
Let me tell you something. If you don't stop when I tell you to stop, I'm gonna take you out of here. So this is gonna be case number 25S00791FY. People of the state of Michigan versus Timothy Dansby. Sir, what's your name? All right, Mr. Dansby, good afternoon. Mr. Shockley, place your appearance on.
On the captain table.
All right, today is the date scheduled for a preliminary examination. This is on one count of retail fraud, first degree. People prepared to proceed.
Yes, Alex.
All right, any preliminary matters?
Did you pursuant to the court rule confirm that the defendant still wishes to represent himself as this is a critical proceeding?
No, but do you still wish? Assume he did.
Yeah, it just has.
He's been he's just been asking all this time. Would you still want to represent yourself? You've been telling us all this time. Do you want to represent yourself?
I've been wanting to represent myself.
Okay, so you want to proceed today by yourself without a lawyer, right?
Not before I let it be known that I still never received my full discovery.
Well, what haven't you received, sir?
I haven't had a chance to go over the videotape because one of the witnesses in the videotape that I know that when I was speaking to him and was saying, letting him know that, look, man, put this stuff back on here because I'm choosing not to buy it here and I'm going someplace else. So it wasn't like I was trying to steal nothing when I told the guy this particular, I wanted to make sure that he's being available to be questioned.
I don't know who he's going to call. See, this isn't a trial. So this is just your probable cause hearing. So the prosecutor has a very low threshold burden of proof. He doesn't have to put on every witness, he said. He doesn't necessarily have to use the video. He might. And if you say the video means something else, that creates a question of fact that would go to trial for the trier fact to resolve. And of course, you get an opportunity to question about the video in depth at trial.
Also, I'd like to mention the fact that, you know what I'm saying, that it's been a delay because I don't know who these people have been coming up here. I've been telling the court that I've been wanting to represent myself.
Well, you've been representing yourself since the last time.
Well, I've done with them at the county jail. They said without the court allowing them to know that I was representing myself, there was certain information I couldn't get. They would not have given me. Like the Michigan court rules of evidence. You know what I'm saying? For part.
I've never heard of the court having to tell the jail you're representing yourself.
No,
I've never heard of that.
The new technology, they used to have a law library you could go. But now you do everything over the computer.
Okay.
You got to leave a request. In order for them to fulfill your request, they have certain criteria that you got to show ahead of time.
Well, sir, I don't know anything about what the jail's criteria is.
And also, I'd ask, for a standby lawyer.
But they don't do that.
Well, from my understanding from previous experience,
What year was that?
From federal circuit court and from other courts.
Federal circuit court.
No, I know it had to be a circuit court. They have done.
This is the state system.
There has been opportunity to have standby lawyer for instances where they could confer certain information that the prosecutor might not want to give to me because he might feel he's better than me or something. Because he feels that my constitution might.
Listen, Mr. Dansby. We can't keep.
Might allow me to receive.
No, of course you got. That's not true. You have a right to represent yourself and you do have a right to get discovery. But what you can't do is come in here on the day of the hearing claiming that, oh, now you want to stand by counsel. Okay, but I'm telling you.
I'm just saying, my experience, it's always been standby counsel been set.
I don't know what your experience is. I just know what Michigan and I don't know when you got.
Well, of information.
Okay, sir. The Michigan Indigent Defense Rules, they have a whole new program that's been started a few years ago. So we used to do standby counsel and anything like that. We used to do that all the time when the court was appointing. Now they have a whole system. They don't pay for that. They say if the defendant wants a lawyer, fine, but there's no quote standby lawyer in their view, so they don't pay for that. I didn't make that rule. The person,
I couldn't verify it if I wanted to without.
well, the person that,
Without the people in the jail who's running the law library information, able to send me the information that I need, because without them having, and for their quote.
okay, what
unquote-
information
Their
do,
quote unquote.
sir, what information do you think you need just for a preliminary exam?
Your Honor, just,
No, I said for Michigan Defense appointment.
So then, you said it used to get standby counsel.
I said we did before that system was created.
Well, I want all the chance to update on the system, y'all.
Okay, but that has nothing to do with this.
Court rules the evidence.
Your Honor, I'm gonna, just so I can expedite this, and to satisfy the defendant, at the circuit court level, the circuit court has the budget and the ability and the staff to appoint a standby counsel once he gets up there. And once we finish this hearing, he may be up there and he can make that request then, and I'm sure the circuit court will have no problem immediately assigning him an attorney to advise him as he represents himself. As far as the people are concerned, the court has been complied with. He's freely and voluntarily relinquished his right to an attorney. May I call my first
So the
witness?
court, so, yeah, I like to also state that I still haven't received my discovery, and my date was proposed because of some guy who said he was my attorney. I did an extra 30 days, the extra 30 days.
Well, if you keep this up,
That's my attorney.
you
Why
gonna,
wasn't my,
you gonna be here another 30 days. Do you want me to adjourn this case again?
No, I don't want to, I'm really actually having dismissed.
No,
For the simple fact that.
we're not doing that.
Or ask for a personal bond, because I've been, had my cases adjourned on other people's. Had nothing.
Sir, you the one that asked for new lawyers or
I
no,
don't ask for no-
or no lawyer.
ask for any new lawyer, because I never accepted the first. I have never signed for an appointment of an attorney from the very beginning, even at.
Okay, sir. Well, we're gonna proceed with your preliminary examination without a lawyer. So you should be happy today that you don't have one. And then when you get to the circuit court, ask them to give you a lawyer. He just said they have a budget for that.
Them give me my discovery.
What discovery don't you have?
See, take-
What tape?
Your Honor, I'm gonna play the tape for him, today anyways. There's no right to it. There's not even a right to discovery before a preliminary exam, technically underneath the court rule. I mean, we deal with this all the time. So this is just an intermediate proceeding. It's not gonna affect anything. As you know, attorneys don't even ask questions a lot of the times during preliminary exams because it creates a question effect.
But they certainly don't call. They might ask questions, but they don't call witnesses.
They don't, not in all situations, in all the preliminary exams, but there's.
Okay. Have a seat, sir, unless you want to stand up for the whole hearing. Call your first witness.
People go to the same Robert Stanley.
Okay, Mr. Shockley, are you ready?
I am ready.
Okay. Raise your right hand. Do solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth.
Yes, sir.
All right, thank you. Have a seat. And Mr. Shockley, whenever you're ready.
Yeah, sir, when you are ready, will you please state and spell your name for the record? Who is your employer?
Meyer,
What is your job title with Meyer?
asset protection team lead.
Asset Protection Team Lead?
Yes, sir.
And how long have you been employed in that capacity by Meyer?
Since January of 2025.
Did you receive any specialized training to have that title or that role?
Yes.
And what do you do? What kind of training?
So it's a multitude. So over years, Wicklander, certified, and then different courses in, asset protection and policy related.
Were you employed in that capacity on July 26, 2025, around 5:30 p.m.?
Yes, sir.
Okay. And so do you work at a specific Meyer store or multiple stores?
I'm assigned to the one in Southfield.
Is that located at 28800 Telegraph Road,
Yes.
City of Southfield,
Yes.
County of Oakland?
Yes.
On that date, around that time, did you identify a retail theft in progress?
Yes.
And how did you identify that?
In this particular case, it was just, rapid selections of, similar merchandise.
What do you mean rapid selections?
So one of the indicators of theft is grabbing merchandise without looking at price or without appearing to look at price, size, that kind of thing.
And how did you see this occurring?
On the floor.
Were you physically on the floor or were you watching cameras?
Sorry, I was physically on the floor.
Did you follow this individual
I did.
as he was selecting items?
Correct.
Do you see that individual you're following presently in the courtroom?
I do.
Will you please point and identify an article of clothing he is wearing?
It's the over to my left, and he's wearing like a blue shirt with a white t-shirt.
Your Honor, may the record reflect the proper identification of the defendant?
Yes, so ordered.
Uh, Upon following this individual, did at one point he come to the point of sale?
He did.
Was that before, at any point did he try to walk out before coming to those points of sale?
No,
Did he have a cart or was he concealing these items on his person?
it was a carton.
Was that cart full?
Yes.
Upon him going to the point of sale, what did you? Just so we put, you were at the point of sale when he got there.
I was, yes.
And what did you see him do at that point?
He went up to a cashier and myself and asked where the bathroom was.
Was that before or after the cash register?
That was, it's kind of at the same time. It's like at a, it's like a giant area where there's like self-checkouts.
Are these self-checkouts?
Yes,
Is there a long looping line to the self-checkout?
correct.
Did he still have the cart with him?
He did. So he left the cart, actually by me, and then he went to the restroom.
And what did he do? Did he come out of the restroom?
He did.
What did he do upon coming out of the restroom?
He grabbed the cart and proceeded towards the opposite side of the store, which would be the grocery side.
And what did he do upon getting to the grocery side?
He pushed the cart out, exiting the store without offering payment.
Did you, stop him at that point?
Yeah.
Did he say anything to you upon stopping him?
He said, I can't recall exactly what he said.
But he did say something?
He did.
Okay, and what did he do upon you confronting him?
He walked past me and then went out the doors going to on the grocery side in the parking lot.
Did he abandon his cart or did he try to take his cart with him?
He abandoned it.
Upon scanning these items, was a receipt produced?
It was.
Yeah, may I approach the witness?
Yes.
People pose exhibit one. What is that?
It's a receipt from Meyer.
And does it fairly accurately depict the items you scanned from the cart?
Yes.
Has that receipt been edited in any way to your knowledge?
No.
People are going to admit people's exhibit one.
Show it to the, him. Okay, sir, that is People's Proposed Exhibit 1. Hello? Well, he's offering it. Is there an objection? Okay, no objection heard, admitted.
Sir, does, Meyer take cameras?
We do.
And were those cameras working operational that day?
They were.
And did, upon him leaving the store, did you contact law enforcement? Did law enforcement come to your location?
They caught him, like in the, they went towards 12 Mile, made a right. I'm sorry, I don't know if it's east or west, but made a right and then they caught it right there. And then they came.
So, okay, so to answer my question, law enforcement did come to your location?
Yes.
Upon them coming to your location, did you show them video for the incident?
Yes.
Previously to you taking the stand, did I show you what's on the splash drive?
Yes.
Is what's on the splash drive, the videos from Meyer that day?
Yes.
People moved to next People's Proposed Exhibit 2.
Any objection?
People's Proposed Exhibit 2 is the camera footage from Meyer, correct?
Yes.
And that's the same footage we turned over to the police? Yes. People moved to next people.
I object to the fact, John, that I haven't had a chance to go over, take previous to the examination. You know what I'm saying? I'd like to state for the record that being able to go there would be part of my discovery. And since the prosecutor said, I guess upon his word, I guess he's making precedence that you don't have to give.
Well, why don't we do this, sir? Let's play the video without admitting it so you can watch it. Then if you have an objection, you can lodge your objection at that time.
Step out.
Who is he?
What-
Why should he step out? He's already seen it.
But he ain't seen it when I'm looking at it. He might be making them different.
No, we're not. He doesn't have to step out. We're gonna show you the video. Go ahead, sir. There's your video.
I'm straight.
You said you haven't,
Video. I was there.
well, you said you wanted to see the video.
I was present, John, when.
Sir, either one way or the other. Are you objecting to the video? Yes or no?
I don't know if it's the whole video or not.
Okay. So
Run the video.
go ahead, play it.
Sir, if you would turn around and look at the screen, is this, one of the videos you provided to?
And I
You can stand.
Yeah, sorry. It's just.
Yeah.
So you showing the video for him or for me?
We're showing it to you, but he's
Yeah,
gonna,
I see you telling him to turn around.
well, he's gonna identify what it is.
I mean,
Then,
If it's my time for me to watch the video, then I watch the video. When it's his time to ask him a question, then he can watch the video.
let's have him identify what it is he's showing. Let's at least do that. Okay, let's do that. Go ahead, Ms. Shapley.
Sir, is this a video you turned over to Southfield Police?
Yes.
Is that actually you in the video?
Yeah, that's, being go on right there.
Okay.
All right, no more questions. Just let him watch it.
Wait, this is at the, this is grocery exit view. This is at the 17-hour, 53-minute mark. So was that you walking out with the,
No questions. Just let him watch it first.
well, that's under that one. That's him leaving the store. He left the store.
I can see what it is. Just let him watch it. Then we'll come back and you can ask questions once he objects or I admit it or whatever, because I'm not admitting it yet.
This video is later labeled GM SCO overview.
Okay.
To the 17-hour, 47-minute mark.
I can't see y'all.
Okay. Well, why don't you walk up there closer?
I'm stopping the video at the 17-hour, 49-minute, 12 second.
Okay. Is that it?
Yes.
All right, sir. Head back to your seat. So that's the video that he seeks to admit. Do you have an objection?
Yeah.
What is that?
Complete video of the incident that happened. Because at this junction right there, I was going to the bathroom and I did not go past.
Okay, but sir, that's an argument. You can make an argument later. The question is this the video that purportedly was taken by Meyer cameras and turned in by this witness to the prosecutor's office? He said that's what it is. Now, you can question the validity of it, the length of it, how long it was, but doesn't affect the admissibility of it. So, okay, so it's submitted. So you want to ask him some questions now, Mr. Shacklin?
Yes, Donna.
Go ahead.
This is of it too, just for the record. Sir,
So you want to stand up and look again?
Oh, no.
He's gonna take you,
Oh, you want me to?
I'm gonna go back.
he's gonna go back to that first video.
And just so we're clear, sir, the time and date, on that video is correct, right?
Yes.
And I'm gonna play now, grocery exit view at the 17-hour, 52-minute mark.
I got look. I'm gonna ask him to play that back.
So is that you confronting the defendant
Yes, sir.
when he was walking onto the exit? Is that after he abandoned his cart?
It's like this part right here, you're talking? Yes.
Yes.
Where's the cart
Do you see the lady?
with the pink hat?
No, man, the, one with like the dark pants and the black shirt right there.
Meyer outfit?
Yes, ma'am. The cart is right there just in front of her.
I'll run it back.
That's the part I'm trying to see. I think, your life.
Yeah, go ahead. Mr. Shy. Oh.
At that point, when he walked up with the cart, right? Yes. And one of your associates takes it away from him?
Correct.
Okay, and then you confront him?
Hold on, wait a minute. Oh, you said somebody took the card away from, where is that at? You should show me that. You think,
Okay,
ask the question, I'm asking you to
sir,
show me.
sir,
Yeah.
no, you don't ask the prosecutor questions. You have to ask the witness questions.
I don't have access to go over the reground and tape myself, yeah, because I haven't been allowed my
This-
copy of the tape or the electronic.
Well, it's not your time to ask the questions yet.
Okay.
You'll get a chance to.
I don't have a copy of the tape to go over.
Sir, you
that.
don't need it. You watched it.
Well, I'm watching it, I'm trying to verify what's going on.
Okay, but you're not doing it right. You have to wait till he asks the witness questions,
Okay.
and then you'll get a chance to ask the witness questions too.
Sir,
I know that.
you see the person in the middle of that video that looks like he's got like a white stripe at the bottom of his leg?
Yes, sir.
Okay, is that the person you identified as the defendant?
Yes, sir.
Okay, that card he appears to be holding it in his hand. Is that the card you took the items out and then scanned to create that receipt, which was People's Exhibit 1?
Yes, sir.
People are good fun.
Where's the copy?
It's right there at the entrance by that lady in the blue shirt and pants. She's holding it.
How did you get there?
You were,
I didn't take it.
sir, if you watch the video, it shows you, he identified you pushing the cart, and when he got to that part, they stopped you
Okay.
and took the cart.
Now they took the car, but there was an individual, it was a young black male.
Okay, sir.
It was, hold on, y'all.
But just, you're not testifying.
It was a young, I'm not testifying.
Yes, you are. You're trying to tell us your story, and this
I'm
is
trying
not.
to tell you that the tape, this is not the full tape.
Okay, this is not the time.
This is not the full tape.
Okay, sir.
This is not the full tape. How can you show half of the tape and then the sequence instead of showing the whole tape? From the times that I left from the times that I left, the black parts with the where I was paying for the tape and walked in there, it's the whole step was missing. So where is the step that's missing from?
You'll get a chance to ask him those questions.
Well, how am I gonna show him if I can't show my?
You'll get a chance to ask the witness that question.
I want to be able to see on.
He's the one who says he made the tape and turned it in. He's the one who would know if there's a section missing or how he copied it.
I should wait for my course of that.
Yes.
Come on back. Wait, I've been for my.
Mr. Shockley, are you done with this particular tape?
Yeah.
Could you do me a favor? Roll it back to the very beginning of this, where there's people coming out of that door on the left. I'm gonna tell you when to stop something. I just want to see something.
Want to keep going?
Yeah, well, yeah, keep going. It's the okay. Okay, play it. Mhm.
Can he stop and take there, Mr. Prosecutor? Can you stop right there? Mr. Shock.
Yeah.
When the defendant was pushing that, was speaking
No.
first.
Sir, no.
No, okay, all right.
Not your turn.
No, okay. All right, well, you have the word, okay,
You gotta play it again when it's your turn.
okay.
A man with long shoes.
That part, the defendant leaves the store, correct?
Yes, it is.
Okay. Now, are you gonna have to play that overhead camera view?
If you would like me to.
I don't know what that was. So if you need it, you can play it. It's part of it.
That's what they do.
That was 17 hour, 47 minute. Sir, I'm pausing the video for a second. Do you see yourself in the bottom left corner of that video? Too small?
First of all, what area of the store is this video depicting?
Your Honor, this is in the GM side, so this would be the north side of the store.
Okay. So service desk to the left,
Yes, ma'am. So if,
and that's where's the are the doors depicted in this? No.
Can I go closer to see?
Yeah.
If I use it? So when you went to the bathroom, it was right this way.
Okay.
Okay. And when I went towards the door, is he takes the cart here and then goes this way down that long aisle. And then it goes into the grocery, which you saw right here.
Okay. So that's what this is depicting. And so that's like the open area where you come in. That's no cash registers right there.
No, ma'am, I'm sorry.
Is that them right there walking? Right up there?
So this is your entrance right here.
Stop, right up there at the top. Is that him?
You'll see her, sorry.
Right there. Is that him?
Gentlemen, I've asked any questions yet? Yeah.
Not yet.
You gotta wait till it's time to cross exam. This is direct exam.
Oh.
Why did you decide to just stand there and wait?
Because he's in the bathroom and that was his cart right there.
You just watched the card?
Yeah, so at that point, it's all I care about with the cart.
Got the defendant right there going to get his card?
Yes, sir.
Do we see the time?
Mr. Shaka, can you show him the timer?
The time.
This is that point, the time when, play frame is 17 hours, 52 minutes. The grocery school, the grocery exit view, when I started playing that video, which is the last video we saw, was starting at 17 hours, 53 minutes. Is it fair to say that he then took his car to that grocery exit?
Yes.
Okay, and that's what you stopped him?
Correct.
I don't know. What was the, do you remember what the value was? I never seen.
Exhibit number 1
Yeah,
says $39.99. Oh, I'm sorry, 207.12.
I believe it's just over 200.
Yeah, that was one item I was looking at. 207.12. Okay, are you finished?
I'm done.
Okay, sir, cross-examination now.
Okay, I'm gonna need to know.
He can play it.
Okay, now,
What do you want him to play?
if this document right here, this is chocolate,
Yes.
salmon,
Yes.
this is salmon. If this point right here, when you finish lesson, the self-pay machines, or walking towards the cash register where it would be taken in, and you went that way, at which point did you start walking behind? Can you run the tape? At which point was you walking behind as you finished? Letting him know that you'd already called the police.
I don't understand. I'm sorry, sir. I really don't understand your question.
Okay, at one point when you put that out there, put him. Yeah. You came behind and said, I'm gonna come to my office, I already called the police.
Yes, sir.
Okay, was that before or after he got close to a rescue?
That was after the exit.
That was after the exit was here,
No, sir. It was, the
after
other.
the exit of the store?
Yes, sir. After the exit.
So when he was walking this way, can you show the text, can you show the text, Mr. Prosecutor, but pushing the car?
You want to see this video that's permanently on?
I want to see the video, the park. It was all on one camera. Can you zoom me into the park where the defendant is pushing the car? Going towards the other exit.
This is the video you want to see, sir, correct?
Yeah, he wants to see where he's pushing the cart going towards the other side of the store towards the groceries. If you can zoom in on it. I don't know if you can.
You could see it better on the roof. So.
Now show us, witness, where he is in this view right here.
I go.
Yeah, going up there.
Right there.
That's the cart and that's him. Okay. So what was he doing at the scanner machine there? Did he scan anything?
Yes, ma'am. He scanned one item and then put that same item back in his cart, never offered payment.
Okay. All right.
Question for you, Mr. Skinner. Did you check that scanner after he left?
I did.
And what did he say?
And one item up there.
And what was the price of that item?
Don't recall.
Because it didn't work.
And so point to him there in that shot. See way down there
Yes, ma'am.
where the pointer is.
Yes, ma'am.
Is it for you approaching?
No, sir.
And who was the other individual, the black young male that was doing?
So, you'd have to show me which one. There was a couple over there.
Can you keep, keep time on? So at that point, when you spoke to the defendant, or spoke to the, was there anybody up there that had a conversation?
I mean, I'm sure those,
No, was there another employee there? Conversation,
like when you and I were talking.
when you approached. Cause now you saying he head out the door?
Yes, sir. So there's 3 employees there total. So myself, another employee, and then, another employee. And then when you and I were talking, it's just.
Hold on. Where is the young male? It was a black guy right there.
There's a black.
Okay, now, you say you come right here, right?
Yes, sir.
Can you show, can you go back to the top, okay. Right here. Can you go back to this part up here? Well, not down, another time, this part right here. Because it appears to be stopped moving. Here, right there. Now, can you run that, showing that part right there? Stop, stop this. What is this right here?
That's the time.
What's this right here?
Huh?
So why is it not in this city? Why is this moving faster than that?
It's you see so that's the 40. Those 3 that goes to those signals.
I understand this is going to be really tricky. I'm talking about this time here and this time here. Why is, what, 17 minus 12 was 5, 17 minus 12?
Yeah, it's
I know, no, 17 minus 12 was time. It's the time. Okay, can you go back, this is probably about 3 minutes? But what I'm trying to figure out here, Mr. Is how
Mr. Attorney, you talked to the witness?
to the witness, yeah, I'm wanting to
The witness is Mr. Salmons.
why I keep saying shot.
That's a prosecutor.
You know what I'm saying?
Hey, I appreciate
Oh,
the
yeah,
compliment.
I
I mean, I'll take it.
At what junction did you say would you like to come to the office with me?
It would be, is it okay to go up? Yeah. I can show.
You can always step up and point.
It would be right here, sir. Like, right, see those towers, just past those towers right there.
And you finna go past those towers?
Yes,
And did they beat?
no, sir.
Why not?
Those towers are what they're called is electronic article surveillance. What they detect is merchandise protection that's on products. Not all products have that merchandise protection. So it'll only go off if one of those products that has merchandise protection.
Okay, so what, so hold on, wait a minute. stop, can you go back one more time, Mr. Prosecutor, about another minute? Cause what happened to the, okay, go back. Okay, so, hold on, now, go forward. 'Cause I'm trying to see which tape is, which with this which. Okay, that's her stuff. He's going in it with her stuff? He's coming out with his, right?
Yes, sir.
So this stuff never went past here.
It did. We went right to the top.
So what happened to, where is this Carter?
That would be, the part that the defendant was pushing, sir.
So it never went past here.
It did. You have to see it. You'll be able to see it, sir.
Okay. I want to see what's in there. Okay, but you say stop. You stop right there. Is that your real brother? Well, you got no baby. Okay, right, okay. This is the individual I need to see, right? Who is this individual right here?
That's another employee of,
Yeah, what's his name?
I don't know the last name, for this again.
Is he part of your team?
My team, no, an employee of mine.
Not an employee of yours?
So, he doesn't work under me, no, he's just an employee of mine. But he's not on, like, my specific team.
So was you close enough with the conversation was held between him and the defendant?
Your Honor, if the defendant's done with the video, I would ask him to go back to his table.
Are you done, sir?
No, I'm only done with the video because I'm trying to figure out, Mr.
Sands.
How did you beat the defendant in the front?
Yeah, that's, so I was following the defendant along the back aisle, where I could keep it, where I could watch while I'm walking.
Okay. So at which point did you, when you was walking behind him, when you was walking behind him, was you out the store?
I was never behind, I was always to the side.
No question, just point. Now, I do like to ask you a question. Are you saying that you know the defendant picking up items without checking the price?
Appear.
It appears to be.
Yes, sir.
So this is how you profile the individual who was coming in.
No, so we don't profile, what we look for is behaviors, so,
Okay, profile behavior, basically kind of like it's the same thing.
uh,
And also, when you went to the scanning machine, you said did you go back and check the thing on the scanning machine, see the scan?
I didn't need to, I was at the, where I was, I could view every scanner and I could see as it goes.
So you seen the one thing get scanned,
Correct.
and you seen the machine activated? Or do you know if it actually scanned?
I don't know what you mean by activate, I apologize.
When you go to the self-care machine and you try to scan
Yes.
it, it's ready.
Yeah, it'll beep and then something.
Right, did you hear it beep?
There's lots, there's like stuff
No
right
further
there.
questions, but it didn't beep because it wasn't working. All right, no further questions.
Mr. Shockley, anything else?
No,
Sir, thank you so much. You may step down. Any other witnesses for the people?
people rest.
Thank you. All right, sir. Do you have any witnesses? Typically, the defense does not call witnesses at a preliminary exam, but do you have any witnesses?
Like I said,
Do you have any witnesses?
I haven't had a chance with the witness that I would have liked to have.
Okay, but you don't,
I wouldn't get a chance because I never got a chance.
sir, you still got a chance at trial to call a witness. This is not a trial. All you're gonna do is create a question of fact.
I can tell you this, Your Honor.
Okay, wait, we're not at the argument.
This take.
Stop. Mr. Shockley is gonna make his motion. Go ahead, Ms. Shockley.
By the defendant over as charged, as you know, this is retail fraud in the third degree, it's enhanced from a second to a first. Dollar amount's over $200, the video shows in the testimony, Mr. Salmon shows that he, attempted to leave the store without making any, ability or offer to pay for those items. Accordingly, we consider bound over as charged. Thank you.
Yeah, what do you want to say by way of argument now, sir?
I'd like to say, Your Honor, that it's been such a long time, I never had a chance to get the tape. You know what I'm saying? And I also like to state.
You went over that tape ad nauseum today, sir.
Like, that tape, the prosecutor had to take so long, but that's not exact, that tape doesn't exactly show what happened. But that individual was walking behind me. I don't know how he did that to tape, that's why I was looking for the time. And also, I like, again, just for the matter of the question that impropriety on the way the examination was ran for the simple fact that the days and the time that it took, even though the prosecutors did show his willingness to show the tape, did not give me a chance to go over the tape. Since we've been postponing this, I haven't had a chance to even call, and I still, to this joint, don't know the witness name of the individual that.
Sir, you got plenty of time to find the witness and call them for trial. This is not a trial.
I'm gonna do it, Your Honor, if I can't get the paperwork.
What paperwork?
I can't get the discovery motion for discovery.
You got a folder full of paperwork.
Look,
A police report, right?
I'm talking about, Your Honor, the paperwork in order to get the discovery, to get.
Now, I don't know what paperwork you're talking about.
Rest of the discovery, the motion to be able to write the motion for the discovery.
No,
The
You-
Michigan court rules to determine that, the Michigan, or you don't know, the Michigan court rules to determine that the prosecutor must.
no, you know what? I have no idea even what you're talking about at this point. You got the police
Also, I like-
report, which gives you all the information.
And for the last.
I'm not quit talking.
I like to put on record.
I'm just gonna stop talking. You can take over this whole courtroom. Go ahead. And you got about 3 minutes to do it.
All right, for the last statement, and I like what state for the courtroom, still that the court never actually showed its authority to trial the individual, because I don't know if this prosecutor, the court, even have license to practice law.
Okay, no, we're not going down that road. Excuse me. Listen.
No,
let me tell-
constitutional right.
Let me tell you something. If
Stop talking to
you don't stop when I tell you to stop, I'm gonna take you out of here. We're not getting into whether somebody has a license to practice law. You are to contain,
It's a legitimate argument.
listen, you're to contain your argument to the facts
And it says the fact.
on this case,
From
this on the record.
the
Let-
Bar Association,
Let
it
her
said
talk.
that it is not a licensed agent. So if you got a bar practitioner without a license, which the Constitution of the United States and the state.
Sir, I'm not gonna listen to that.
No state,
Nope.
no city, no township, municipality, can make a law contrary to
Nope.
the highest law of the land. Now, for that to be placed on the record.
Is placed on it. Now, you're done. The defendant is charged with a retail fraud. All the elements were met in this matter for retail fraud, first degree. The testimony clearly established that the defendant took property of the store that was offered for sale. It showed by way of testimony that he took property off the shelf in a random manner. The testimony was all the same things without looking really at the prices or the tags, it seemed like. That he moved the property, he put it in a basket and walked all around the store from one side to the other. Third, he intended to steal. That's a question of fact. As to whether or not he intended to permanently deprive the store without the store's consent. However, it was clear from the video shown that he walked from one entrance to the other entrance without paying for anything and was attempting to push his cart through the entrance when he was stopped by loss prevention from doing so. That's the question of fact, as to why he was doing it with the intent to permanently deprive or not. And this really happened inside the store while it was open to the public and without the consent of Meyer. The items were tallied up by loss prevention and came to $207.12. So clearly, that's enough to satisfy the court that the retail fraud did occur. And of course, there was an allegation that he apparently had a prior conviction, April 17, 1989, for retail fraud, first degree of the Sixth Circuit Court. So that's the sentencing issue, and that's enough to bind it over on the first degree and continue to bond. Mr. Shockley, here is your exhibit back. His bond is continued. Make sure you get a license to practice law, please.
And don't, present doctored video. Video's been doctored and altered. Oh my God.